You probably didn't imagine yourself Googling how to get a divorce in Wisconsin. And like most people, you're wondering, do I need a reason to file? What if they cheated? What if I'm just not sure? Here's the truth. Wisconsin law does not care who is at fault. And the biggest mistake that people make here is assuming that the judge wants to hear the details of your story. I'm Jeff Hughes, lead attorney and CEO at Sterling Lawyers, and we have helped thousands of Wisconsin families navigate family law cases from start to finish. In this video, you will find out exactly what qualifies for divorce in our state and how to navigate the process without costly mistakes. A client once came in, and I'm going to call her Kim. She was furious. Her husband had cheated, drained their bank account, and moved in with someone else. She had the receipts, the text, the photos, the whole thing. She told us, I want the judge to know what kind of man he is. And I had to tell her the same thing that I am going to tell you here. Wisconsin law does not care. That is because we live in a no-fault divorce state, and it has been that way since 1977. Truth number one, the only grounds for divorce in Wisconsin. There is just one legal requirement in Wisconsin, and that is that the marriage is irretrievably broken. That's it. Not adultery, not abuse, and not abandonment. It doesn't matter if they left you, or you still love them, or you are a great parent, or they ruined your life. If one person says under oath that the marriage is irretrievably broken, and the court agrees that there's no reasonable chance of reconciliation, you can get a divorce. Truth number two, there are two ways to prove that the marriage is irretrievably broken in Wisconsin. The first is if both spouses agree. So if you both show up to court and you say, we are done, the judge will mark that as irretrievably broken with no further proof needed. The second is if you have lived apart for 12 months. Even if one spouse wants a divorce, if you've lived apart for a full year, you can say under oath that the marriage is over. The court must grant it. Truth number three, what is not grounds for divorce? So let's bust a big myth here. You do not need to prove infidelity, emotional abuse, substance abuse, mental health issues, or financial mismanagement. However, will those things matter later when it comes to custody or asset division? Yes, maybe, most likely. But as far as getting the divorce, no, they won't matter. They're not relevant to proving that the marriage is over. Truth number four, what the court does not care about. If one of you says that it's over and the court agrees there is no future, the judge will move forward with a divorce. So the judge just doesn't care about what the other party may or may not say. It takes one spouse to say this. The system of no-fault divorce is designed to avoid blame and focus on resolution. Now let me shift gears and talk about a legal separation, because everything is the same between a divorce and a legal separation except the final resolution. In the final resolution, all the property is dealt with, the children are dealt with, support payments, alimony payments, they are all dealt with. However, the marriage is still intact because neither party has said that the marriage is irretrievably broken. They have said it's broken, it is not irretrievably broken. So here is how that works going forward. If you are legally separated, you can stay legally separated until death, or either party can come back after a full year of separation and say the marriage is now irretrievably broken. It's simply as filing a form with the court, and the judge will convert that legal separation to a divorce. Or after the legal separation is granted, both parties can testify and say that the marriage is irretrievably broken. Then the judge will then convert that legal separation to an ultimate judgment of divorce. That's not a loophole. It's just a different path to the same outcome. And one more thing, let me close with this. Even though fault isn't a ground for divorce, certain bad behavior can still significantly impact your case. If your spouse wasted money on an affair, the court might penalize them during property division or alimony payments. We call those maintenance payments in Wisconsin. If abuse or addiction is an issue, that can affect custody decisions, and oftentimes does. If one party caused financial harm, the court can adjust support and attorney fees accordingly. But none of that is needed to start a divorce case or to conclude one. You do not have to dig up dirt. You just have to declare that the marriage is irretrievably broken. Now, once you've confirmed that the marriage is legally over, the next question is, what do I need to do right now before I file? Even in a no-fault divorce, what you do in the first few weeks can shape your entire case, financially and legally. So watch this next video where we'll walk through the exact steps to take before you file so you don't end up wasting time, blowing your leverage, or hurting your chances with the children. See you over there.